Hey, last night we were reading the Federal Rule of Civil Procedure, and we were stopped at discovery. And thus, what I'm going to do is read everything from my note cards. That I'm skipping through all of this jurisdictional stuff. The laws of the several states, except where the Constitution or treaties of the U.S. or acts of Congress otherwise require or provide, shall be regarded as rules of decisions in civil actions in the U.S. courts in cases where they apply. Sorry, that's probably giving deference to the state laws as rules of decision. Not important. So I read that. Ex parte, not really all that important. Process that deprives the opposing party of the opportunity to contest the validity of information received in discovery. I don't know if I believe that. Okay, but JMOL's one thing, curing defective venue. I'm not sure if we went into venue in the rules 1 through 26, but everything we'll return to anything in rules 1 through 26 after I get through the discovery rules, basically from my note cards. I just don't remember if we talked about venue. So here's another crazy one that Mom wrote on a note card. Declaratory Judgment Act from the Surface Supplied versus Kirby Morgan case. I asked her to write about venue, which is proper in one, a judicial district in which any defendant resides, if all defendants are residents of the state in which the district is located. 2, a judicial district in which a substantial part of the events or omissions giving rise to the claim occurred, or substantial property as part of the action. Or 3rd, if there is no district in which an action may be brought, any judicial district in which defendant is subject to the court's personal jurisdiction with respect to such action. So, interpleader, we already talked, I believe, about interpleader, intervention, supplemental removal. What's this? More venue, curing a defective venue. Venue is proper. I'm just going to read this again because on different note card, in a district where any defendant resides, if all defendants reside in the state where the federal court is located. 2, the district in which a substantial part of the events or omissions giving rise to the events occurred. Or 3, if neither I nor ruminant 2, action may be brought in a judicial district in which the defendant is a subject to the court's personal jurisdiction. Curing the defective venue, the district court of a district in which case is filed, a case laying venue in the wrong division or district shall dismiss, or if in the interest of justice, transfer such case to any district or division in which it could have been brought. Just since we're on the topic of JMOL, I'm going to leave my note cards here pertaining to joinder. And I want to start there if we get through the rest of my basically book of note cards here. Before JMOL and Riveter, and new trial, forum nonconvenience. Let's read about forum nonconvenience. Location of parties and evidence, applicable law, administrative problems, and language barriers. That's some example of what you would argue in forum nonconvenience. Work product, document prepared in anticipation of litigation by a party or its representative are not discoverable unless the opposing party can show substantial need and that it couldn't obtain materials in an alternative way without undue hardship. Okay, we can skip that. This work in progress. Kind of just read that. Here in shorthand, it's prepared in anticipation of litigation. Don't forget that. Rule 34, this has to do with the discovery. What does this say? Requires party to produce relevant physical material, including ESI, which is electronically stored information. Okay, rule 15, we can kind of skip, but I know that's the relation back. I'm going to read it. I read anything that's in the note card book, right? I suppose. This one's leave of the court to grant motions to amend is to be freely given when justice so requires. So no specific deadline requires. Proposed claim. I don't know what that says. Something about amendment. Filing stems from the same facts in the complaint. So did not something at the time of original filing. I don't know what SOV stands for. So, whatever, that was nice. JML's here. I'm going to read that later, but this is also known as a directive verdict, and it's available to any party at any time before submission of the case to the jury. When written and read is 28 days after judgment to file renewed. JML is aka JNOV. Nothing's written on that card. Rule 16, attendance and matters for consideration at a pretrial conference. Read that yesterday. Pretrial conference scheduling, management, and sanctions. Read that yesterday. Pretrial conferences. Read that yesterday. But for purposes of pretrial conference and any action, the court may order the attorneys and any unrepresented parties to appear for one or more pretrial conferences for such purposes as to facilitate settlement. Attendance, if appropriate, the court may require that a party or its representative be present or reasonably available by other means to consider a possible settlement. Default judgment, Rule 55. I don't have anything written here. 16, scheduling orders for discovery. Nothing written there, but I talked about it yesterday. So here's discovery scope and limits. Rule 26. There's a couple note cards on it. So for number 1, information produced. If information produced in discovery is subject to a claim of privilege or of protection as trial prep material, the party making the claim may notify any party that received the information of the claim and the basis for it. After being notified, a party must promptly return, sequester, or destroy the specified information, and any copies it has must not use or disclose the information until the claim is resolved, must take reasonable steps to retrieve the information if the party discovered it before being notified, and may promptly present the information to the court under seal for determination of the claim. The producing party must preserve that information until the claim is resolved. All right, so Rule 26, signing disclosures and discovery requests, responses, and objections. Nothing's written there. Rule 26F, parties must develop a discovery plan. 26F, conference, parties must confer to consider claims, defenses, possibility of settlement, initial disclosures, discovery plans, submit discovery plan to the court, discover the plan to address timing, form of required disclosure, subjects on which discovery may be needed, timing and limits on discovery, relevant orders may be required by the court. 26A1, duty to disclose, general provisions governing discovery, required initial disclosures. Identities of people with knowledge of discoverable matters are discoverable, regardless of the extent the parties, possibly the defendants, investigatory efforts. FRCP 37, failure to make disclosures or to cooperate in discovery sanctions. I don't have anything written there. FRCP 26B 5B, discovery scope and limits. Discovery may be had of any non-privileged matter that is relevant to any party's claim or defense that is proportional to the needs of the case. Rule 45, 3A. Rule 45 governs the issue of subpoenas in the federal system. Her advisory scope of discovery through subpoena is the same as that applicable to Rule 34 and other discovery rules. Under 26B. If standards of FRCP 2634 are not met on timely motion, the court by which or subpoena was issued shall quash or modify it if it subjects a person to undue burden. So what else is in here? Judicial proceedings shall have the same full faith and credit in every court within the U.S. and as they have by law or usage in the courts of such state, territory, or possession from which they are taken. Federal rules of evidence. 401. Prior action had to be concluded in valid final judgment on the merits. Okay, wait a minute. That one's not the evidentiary rules. 401. Relevant evidence has any tendency to make a fact more or less probable than it would be without the evidence, and the fact is of consequence in determining the action. So, before I jump into issue preclusion and claim preclusion, I think the only note cards that I have about trial matters is probably this JMOL, which a judge may grant JMOL, which is a judgment as a matter of law, when the evidence viewed in the light most favorable to the party against whom the verdict would be directed. 2, including all legitimate inferences in their favor. 3, without considering the credibility of witnesses, that a reasonable juror could come only to one conclusion. This JMOL must be raised before submission to the jury and renewed within 28 days. Doesn't have to be renewed. It could be, you could get a director's verdict right then and there, but to renew, you have a motion for a new trial. At least that's the note card that I'm about to read. Available because an error during the trial, usually going to the admissibility of evidence or the propriety of jury instructions, because the verdict is against the weight of the evidence, limited to cases where the judge finds the verdict seriously erroneous, because of jury misconduct, or because the verdict is excessive or inadequate. That's the definition of a motion for new trial. I think it needs to be, it certainly needs to be asked for within a period after the judgment, but I don't have that written here. I also don't have the renewed motion judgment as a matter of law. But JMOL, I should say, I don't have that either. What do I have? I have a remitter note card, which is jury's compensatory damages award is so excessive as to shock the conscience, or in a diversity case, if the award meets the state standard for excessiveness, the judge may order a new trial or offer the alternative of remitter. The plaintiff is given the choice between accepting the award, lower the award by the jury, or submitting to a new trial. All right, so let's read claim preclusion and issue preclusion before we start kind of backtracking into joinder third-party claims. So claim preclusion, let's just start there. Prior action had to be concluded in a valid Final judgment on the merits. Claim and prior action must be the same per the transactional test, and the parties of prior action must be the same, identical or in privity. Identical positions or in privity. For issue preclusion, so that claim preclusion, also known as re judicata, valid final judgment on the merits, claim and prior action must be the same, and the parties must be, or their privies must be in the same positions. Judicial proceedings and issue preclusion shall have the same full faith and credit in every court within the United States as they have by law or usage in the courts of the same state, territory, or possession from which they are taken. That's not issue preclusion. Okay, issue preclusion is the issue to be precluded in subsequent litigation must be the same issue that was raised in a prior litigation that resulted in a valid final judgment. The issue must have been actually litigated and determined in the first case. Resolution of the issue must have been necessary to the judgment in the initial action, and the subsequent action must involve the same parties or their privities. Now we're going to go back to third-party claims and joinder and all that. So, what is third-party claim? Lack of personal jurisdiction is... No. A defendant may assert a third-party claim against a non-party who is or may be liable to it for all or part of the claim against it. Derivative is my first bullet under this. Seeking indemnification or contribution is my second bullet under this. And the defendant may not bring a third-party claim if the defendant believes he is with off amount. I don't know what that says. Okay, so that's third-party claim. Now let's read joinder from here. Federal law claims and state law claims. It might be a good place to start. If a civil action includes a claim arising under the Constitution, laws, or treaties of the United States within the meaning of Section 133 of this title, a claim not within the original or supplemental jurisdiction of the district court, or a claim that has been made non-removable by statute, the entire action may be removed if the action would be removable without the inclusion of the reading my mom's note cards, and they're all like crazy and out of order and unrelated to the subject on the front. She clearly did not understand this at all. She did not understand the assignment. I don't know what subparagraph B claim means, but that's what it says. Upon removal of an action, described in paragraph 1, district court shall sever from action all claims in paragraph 1B and shall remand the severed claims to the state court. Only defendant described in 1A are required to consent to. Thank you, Mom. She's using her lay abbreviations and making this so much harder. I ask her to write these things out for me because I don't feel like writing them out in full. So then she tries to abbreviate them. It's like, well, if that was the case, I use my own abbreviations to make the process shorter. Oh my gosh. All right. Removal. So now we're talking about jurisdiction. I wanted to talk about joinder, but now we're talking about jurisdiction. Any civil action brought in a state court of which the district courts of the U.S. have original jurisdiction may be removed by the defendants, and only the defendants, to the district court of the United States for the district and division embracing the place where such action is pending. That doesn't seem so hard now, right? Okay, so here's supplemental jurisdiction. and maybe the other supplemental jurisdiction, because there's 2 no cards on this. Thanks, Mom. Okay, so in any civil action, this is B. Is this A? Okay, let's start with A. 1367A. Except as provided in subsection B and C or by federal statute in any civil action originally in district courts, the district courts shall have supplemental jurisdiction over all other claims in the action in which they form part of the same case or controversy under Article 3 of the U.S. Constitution. Such supplemental jurisdiction shall claims involving joinder or intervention of other parties. And Part B, in any civil action of which the district courts have original jurisdictions, diversity, solely in Section 1332, which is diversity of this title, the district court shall not have supplemental jurisdiction under subsection A over claims by plaintiffs made parties under Rule 14, 19, 20, or 24 of the Federal Rules of Civil Procedure, or over claims by persons proposed to be joined as plaintiffs under Rule 19 or seeking to intervene as plaintiffs under Rule 24 when supplemental jurisdiction over claims would be inconsistent with the requirements of diversity jurisdiction, Section 1332, which I had to translate. Thanks, Mom. But she wouldn't know, so that is fine. So now we're going to read about intervention and interpleader. Let's start with interpleader. Permit stakeholder to require 2 or more claimants litigate among themselves when a valid claim may result in double liability or a single obligation. On the back, I have Rule 22, which is Federal Rules of Civil Procedure. Normal rules for subject matter jurisdiction apply, such as federal question and diversity. Federal statute loosens the restrictions of subject matter jurisdiction to greater than $500 amount in controversy and diversity between any 2 contending claimants. That's all written on the interpleader card. So rule interpleader and statutory interpleader, I think, is how you differentiate. Now, intervention. As a right, when applicant claims in an interest in property or a transaction that is same of action, or that is subject matter of action, and disposition of action will impair ability to protect that interest, intervention as a right, arises now for permissive, timely, with court discretion, I've written in parentheses, applicants' claim or defense and main action have question of law or fact in common, no personal or pecuniary interest is required, and it requires subject matter jurisdiction grounds. So let's keep moving, actually. Here's where I'd love to talk about Rule 13 and Rule 19. And you know what? I have them in my outline sitting here. I opened to this page for a reason. Counterclaims, Rule 13, permissive counterclaims versus compulsory counterclaims, which is ruled by the transactional test. Res judicata and collateral estoppel. Okay. I think what I'm getting from this is that there's subject matter jurisdiction over counterclaims from this same transaction or occurrence, unless precluded. But let's just, or no, you're precluded if you don't bring them, the compulsory counterclaims. Do you have any more on this? Compulsory party joinder under now Federal Civil Procedure 19 Joinder of necessary parties when feasible, necessary elements, no complete relief in the non-party's absence, impairment to non-party's claimed interest, existing party at risk of multiple or inconsistent obligations. Feasibility elements include personal jurisdiction, subject matter jurisdiction, venue, supplemental jurisdiction. Okay, indispensable parties. So that's I think that's the definition of necessary parties. Indispensable parties, I feel like they're determined by the same test. But I see here necessary parties absence is so critical that the case must be dismissed in absence, whereas indispensable party analysis, there's 4 factors: resulting prejudice to all parties, mitigation, avoidance of prejudice, adequacy of remedy, and adequate remedy elsewhere. The court must determine, after analyzing the 4 factors, whether in equity and good conscience the action should be dismissed. So the next section is intervention. So I'm going to go back up and talk about permissive party joinder. Under rules of Federal Rules of Civil Procedure 20A, also in Mosley v. General Motors Corp. 20A, claims arising out of the same transaction or occurrence and common question of law or fact. That's it. Whereas compulsory, why is that not really defined? I can't possibly be only defined in the Federal Rules of Civil Procedure 19. Third party practice, FCRP 14, that's the impleader we talked about. Other outlier only third party pleading practice predicated on derivative liability. Yeah, this outline is really nice, not? Talks about interpleader after intervention as a right. Let's just do this one more time. Intervention as a right, federal statutory authority, or claims and interest relating to the property or transaction that is the subject of the action and so situated that disposing of the action may, as a practical matter, impair or impede the movement's ability to protect its interest unless existing parties adequately represent that interest. And permissive intervention is that a claim or defense that shares a common question of law or fact with the main action. The typical evaluation is the degree of overlap between the 2 actions, the extent of progress in the original action, the impact the intervention would have on the original action, the availability of alternatives to intervention such as consolidation. Interpleader, lawyer holding property in escrow for judicial efficiency. Okay, person in possession of property he doesn't own and can join anyone who may have an interest to determine ownership and stakeholder need, no risk of further. What? That's a contest. I don't even know what that means. Consent. I don't even know what that means. How am I making this so much harder? It's because I don't have the reason yesterday that I was reading the Federal Rules of Civil Procedure is literally because my notes make no sense. And my note cards make no sense. So let's go to complaint. Let's start at the beginning. A short statement of the grounds for the court's jurisdiction. A short statement of the claim showing the pleader is entitled to relief and a demand for judgment for relief, whichever may be in the alternative. I'm sorry, for judgment for relief. Talks about curing a defective venue. Talks about this random time that venue is proper a couple times. Those 3 things. And the order was always the same. A judicial district in which any defendant resides. A judicial district in which a substantial part of the events or omissions took place. And if nothing else, anywhere that a court has personal jurisdiction of the defendant. Long-arm statute executing personal jurisdiction over the defendant varies by state. Circumstances in which permissible in circumstances where the defendant has minimal contacts, the courts don't execute this to the fullest extent. circumstances in which they wish to exercise personal jurisdiction over the defendants through jurisdictional statutes, aka long-arm statutes, whatever, in rem. If jurisdiction is based on the court's power over property within its territory and action is in rem or quasi-in rem. And responding to a complaint. A defendant may raise a number of defenses by pre-answer motion in response to a complaint, but some must be consolidated or raised initially or they are waived. Rule 12G and H, defendant is obligated to submit an answer which can include non-waived defenses and objections, but must include admissions or denials of factual allegations, affirmative defenses to be raised, and assert counterclaims. Any more? Yeah, there's a couple more. So, amend a complaint relation back. I think you read this. Amendments substituting a new defendant for one originally named are allowed, and the amendment will relate back to the time the original complaint was filed. If one, the claims in the the claims in the amendment arise from the same transaction and occurrence as the claims set out in the original pleading, and two, within the time allotted for serving the original complaint, 90 days from filing per, what's that? And the new defendant receives such notice of the action that it not be prejudicial in defending on the merits and knew or should have known about the action. I know what I'm trying to say there. So Rule 4K is the next thing. Personal jurisdiction in the federal courts. Territorial limits of effective service. 1, in general, serving a summons or filing a waiver of services establishes personal jurisdiction over the defendant. And A, who is subject to the jurisdiction of a court or general jurisdiction in a state where a district court is located. B, who is a party joined under Rule 14 or 19 and is served within a U.S. judicial district not 100 miles from where the summons is issued. And C, when authorized by a federal statute. Federal claim outside state court jurisdiction for claim. This is part 2. A federal claim outside the state court jurisdiction for a claim that arises under federal feds serving a summons for filing a waiver. A, defendant is not subject to jurisdiction in any state courts of general jurisdiction, and B, exercising jurisdiction is consistent with U.S. Constitution and laws. So all that's been said, have I got anything else besides my own outline here? Yeah, and I don't know where the Barbie outline is or where any of my pinups are, basically. So like any quick facts about this. So gonna have to like leave it at that. Let's say that I reviewed this.